Good day, I read to Dr. Asfalilau. We are from Group A, going to be presenting about the cheating offences as according to the Penal Code in Malaysia. But first of all, I want to introduce each one of our members. The first one will be Sinira, then followed up with Aina, and Noor Amira, Noratika, and me, myself, Adriana, and my metric number is 273002. So to begin with, we have to understand that the rate of cheating cases in Malaysia has shown a significant number following the outbreak of COVID-19. However, this issue of cheating is not a recent crime. It has been happening since forever. However, the most prominent example that we could give you would be the story of Macau scam. So scamming is one of the cheating offenses. However, this usually happens in the technology world. Therefore, cheating cases does not only limit it to that kind of circumstances, it opens to different situations and form as well. Before we are able to go deeper into the analysis of the cheating cases itself, we have to understand its definition. So for its formal definitions, we can refer to section 415 of the Penal Code, where by paragraph A, it mentions that fraudulently cheat a person to induce or to consent them in delivering their property to any person, while as by paragraph B provides that any persons with the intention to induces a person to do anything that he would never do if he has not been induced to cause damage or harm to any person's body, mind, reputations, and property. So the prosecutions are required to fulfill the elements either this to paragraph. So as for informal definitions, we can refer to Stanley Yu, one of the authors of the criminal law in Malaysia and Singapore, which he has defined cheating as deceiving another person into believing something, as a result persuading them to act as the proprietor desire. So these presentations will go through the analysis of it, the advantages, disadvantages, and what we could improve toward our laws. So let's go to the next presenter.
Assalamu Alikum and very good day everyone. My name is Ramen Tiraji with metric number 267918. In I will cover the part of the main section and current issue based on the law for the offence of cheating. First of all, Section 415 to Section 420 of the Malaysian Penal Code are the main section relating to the offence of cheating. Cheating is a crime that has been defined under Section 415 of the Penal Code. Next, Section 416 of the Penal Code addresses one of the type of offence of cheating, which is cheating by personation, which occurs when someone cheats by claiming to be someone else. It does not matter whether the person they personate is real or fictional. The punishment under this section is imprisonment for a term up to 7 years, a fine or both, as has been stated in Section 419 of the Penal Code. Another type of offence of cheating is cheating with knowledge that wrongful loss will be caused to a person whose interest the offender is bound to protect, as has been stated in Section 418 of the Penal Code. The punishment of the offences in this section same as punishment of offence of cheating by personation, while Section 417 of the Penal Code provides the least severe punishment for cheating, which is imprisonment for a term up to 5 years, a fine or both. Lastly, Section 420 of the Penal Code shows the final form of cheating, delivery and dishonestly inducing the delivery of property. This section is quite similar to Section 415 of the Penal Code, but this section carries a harsher penalty, which is imprisonment for a duration of not less than 1 year and not more than 10 years, as well as whipping, and shall also be liable to a fine. Issues. Firstly, in the year 2020, the issue that arose is there are several loopholes and limitations in the Penal Code to constitute the offence of cheating, such as Section 415 of the Penal Code stipulated onerous requirements to be met, such as the victim must under influence to do or omit to perform specific activities. Another issue is from 2018, where numerous elements are necessary to create the offence of cheating as required by Section 415 of the Penal Code. And another one is the issue on the conviction for the offence of cheating may not be complete unless the delivery of property caused by the deceit also emerge. Issues emerge as a result of the elements themselves, which are too vital to be fulfilled for someone being convicted of cheating. Without the element, it will be difficult or impossible for someone to be convicted for this offence. All from me, thank you. We will proceed to the next representative.
Hi, my name is Joanna Kamila binti Zalizan, matrix number 268097, and I'll be explaining on the advantages on the law imposed on cheating offences. So it is to be understood that cheating offences provides one of the biggest threats to the general public in terms of number of cases and the amount of loss, in which is why the existence of the provision provided in the Penal Code from Section 415 to Section 420 serves its importance. The advantages of the law provided in the Penal Code regarding offences of cheating is to charge the party committing the offence and provide protection towards the person who could be deceived. This provision provides protection in a way that it imposes punishment towards the perpetrators who commit such acts. Based on an article by Noratika, it is provided that the expected punishment imposed on a certain crime does affect the decision-making process of the criminal and also affects the tendency of the committing of said crime. The risk and punishment imposed of the said offence are evaluated by the prospective criminals before committing the said crime. As the punishment imposed in Section 420 of the Penal Code provides a punishment of imprisonment not less than 1 year and not more than 10 years, accompanied with whipping and also a fine. This provision provides a minimum number of years of imprisonment, which ensures that the convicted person be charged of the offence and must be punished no matter what. Other than the punishment imposed, the arrest rate could also be a deterrent of the offence of cheating, causing the reduction of this criminal activity. So, this provision truly provides protection towards the person who are to find themselves being the victim of the offence of cheating. Next, I'll be discussing on the disadvantages of the law imposed on cheating offences based on the Malaysian Penal Code. This is due to the fact that cheating offences cover a variety of criminal activities such as deception, impersonation to deceive, phishing, scamming, dishonestly inducing delivery of property, and many others. The provision of cheating offences governs a wide interpretation of transactions involving deception. In order to bring forward a case for the offence of cheating under the Penal Code, the elements must be proven, which is the act of cheating, acting dishonestly to induce another person, and the mens rea of the deceiving party at the time of the inducement. Deception is one of the keys of the offence of cheating, as it causes the other party to trust a misleading fact with a fraudulent and dishonest intention. Mens rea of the deceiving party in the offence of cheating must be intentional. In order to prove the offence of cheating, it is necessary for the prosecution to prove that it was the intention of the accused. As intention is difficult to prove and it is up to the prosecution, it becomes difficult to impose the offence of cheating on the deceiving party. Data provided by the Royal Malaysian Police shows that only a small number of cases are investigated and even a smaller number of cases succeeded with an arrest. In the case of public prosecutor against Roslan Imun, it is provided that the offence of cheating is recognized as difficult to detect. Cybercrimes involving scams, phishing, and online deception are also governed by the provision of cheating under the Penal Code. Cybercrimes are even more difficult to charge in court due to its lack of evidence and subsequently difficult to prove the elements of cheating offences. From Section 417 to Section 420 of the Penal Code provides a punishment that is to be imposed for the offence of cheating. However, only Section 420 of the Penal Code states the minimum and the maximum number of years of imprisonment. Providing a minimum punishment provides that the perpetrator must be punished with a guaranteed minimum prison sentence. The other sections fail to provide a minimum number of years of punishment and only provided the maximum number of years of punishment. Having a minimum punishment is essential as it acts as a deterrent from the commission of the criminal acts due to the risk it provides. Thus, the lack of punishment might be taken into consideration for the commission of the offence of cheating.
Assalamu Alikum and good day. My name is Ramen Tiraji and my matrix number is 272687. I will be presenting on how the law regulating cheating offences can be improved. Our first suggestion is to add minimum period of imprisonment punishment in Section 417, Section 418 and Section 419 of the Penal Code. Even though it is the discretionary power of the court to specify the period of imprisonment or amount of fine, but by stating the minimum period will make the legal grounds conviction clearer. If those provisions in the Penal Code provides the minimum period of imprisonment, it will give a clear guideline for the judges and prosecutors to decide the appropriate punishments based on the facts of the case. Without minimum standards stated in those provisions, offenders may be passed with inadequate period or amount of punishment. For instance, the Section 420 of the Penal Code clearly states the minimum period of imprisonment for the offence is 1 year. Therefore, the judges and all prosecutors have to have the clear conviction ground that they should not go below the provided period. For further clarification, for the amount of fine, the legislature should not provide the minimum or maximum amount. This is because it will be more adequate for the amount of fine to be determined by referring to the loss value in the facts of the case. This can be compared in section 341 until section 348 of Thailand Criminal Code, where the court in Thailand has to comply with maximum fine that put forward in those provisions. In this consequence has affected the decision of fine to accuse with higher amount to be proportionate with the amount of loss, and it will be advantageous to the offender as they only liable to pay the maximum fine as stated in those provisions regardless the actual amount of loss. Thus, to strengthen the law under Malaysian Penal Code, the legislature should amend Section 417, Section 418 and Section 419 of the Penal Code by adding the minimum period of imprisonment, but the amount of fine should not be limited as seen in Thailand Criminal Code. Furthermore, it will make sure that all cheating cases will be treated with the same minimum standard if imprisonment should be implemented as the punishment for the offence. However, the court still have the discretionary power to decide the punishment, either maximum or minimum period according to the facts of the case. To conclude, by providing a high minimum period of imprisonment as the punishment, it can make the offence of cheating considered as a serious offence. That's all from me. Thank you.
Assalamualaikum, my name is Noratika with metric number 2720805. So now I'll continue on the improving part. As we all know that nowadays there are a lot of cyber crimes occurs that involve cheating offences. For example, online deception, online scam and phishing. So our group suggests that this is the right time for the legislature to take action in expanding the coverage of the provisions regarding to cheating offences provided in the Penal Code. So from our opinion, the legislature should expand the coverage by making an amendment on Section 415 of the Penal Code. This because Section 415 of the Penal Code does not include as to whether the act of cheating is done by one person or more than one. So this because some people think that the provision is only applicable for one person and not more than one, according to the illustrations listed under this section, where the example shows that the act of cheating is done by one person to another person. So, the legislature should include this sentence on this section, as nowadays there are a lot of people who are deceived by not only one person but also more than one person. So, if this included in this provision, the legislature can provide another punishment that are more harsher for them. This because the more people working together under such bad intention, the more victims they are to deceive. Not only that, some people also think that Section 415 is only applicable for deceiving a person in direct circumstances based on the illustrations provided under this section, like in illustration H, where the victims are directly deceived by the accused. However, in current situation, there are many people who use technology and internet to deceive people. So, there is no direct and physical interaction between the victims and the accused, which means that they do not know each other. It is recommended for the legislature to make an amendment on Section 415 of the Penal Code by adding that a person who acts directly or indirectly will still be considered as an act of cheating. Secondly, we also suggest that the legislature should amend the illustrations that had been listed in Section 415 of the Penal Code. It is necessary to make some changes and update the illustrations provided so that it can be in accordance with the current situations right now. Illustrations is very important because it helps people to know and understand how the provisions work. The illustrations that have been provided in these sections are not relevant with the current situation because these illustrations have never been changed from the day it was passed until now. So therefore, we think that the legislature should make some amendment on these illustrations. So that's all from my part. I will pass to the next presenter.
So finally, we got onto the conclusion. So seeing from the analysis that has been done within the scope of cheating, we can conclude that there is a little bit of requirement to improve our legislations, because the first issue being that the only sections that provide the minimum and maximum punishment were Section 420. However, there is other sections or provisions that is govern cheating offences. However, they are not including minimum punishment, thus it could somehow affect the court decisions, and as well as it will be hard on the court to decide and to determine which suitable jail term and punishments to be put forward for the accused. And next would be there's too much elements that is required to be fulfilled by the prosecution. There is also issue with the sections that does not provide whether these sections could be used for a group of people who deceiving other people, and there is also no clear view whether cheating offenses can be done indirectly, because most of the illustrations that has been provided in the penal code itself has shown direct or physical circumstances of cheating. Thus it is a suggestion from us to include indirectly circumstances, because as of today cyber crimes are also being governed by the penal code. So this is only our suggestions and our humble opinion. So thank you very much, and bye bye.